This is current federal tax developments for the week of May 9th, 2016. And this week we'll be looking at some cases, including the IRS deciding that we need to fire partners who are employees of disregarded entities, a spouse with innocent spouse treatment that we'll have a little fun with. The IRS is going to give some relief for QSST elections that were turned out to be needed after a merger, and there's going to be a new comprehensive set of automatic accounting method changes issued. And this week also, we're going to do this a little differently. And so I'm also bringing in here another member of Nichols Patrick. And Don, you want to introduce yourself and tell everybody what you're up to and what you're here and your background?
Hi, yeah, it's good to see you, Ed, and it's good to be here on the broadcast today. My name is Don Cochran. I've been working with Nichols Patrick for about 6 or 7 years now. My background is that I am an attorney and a CPA. I practice in Minnesota, and my areas of concentration have always been in taxes, estate planning, and small businesses. So some of the topics we have here that we're going to talk about today really hit into the areas that are important to my clients, as I'm sure will be for your clients as well. So great to get started here this morning.
Okay, glad to have you on. As I said, this is our current federal tax developments here for the week of May 9th, 2016. As always, this is brought to you by Nichols Patrick CPA Incorporated and your state society of CPAs. Want to remind you that, of course, we're in CPE season, so it's registration time. Here at Nichols Patrick, we have a number coming up over about the next month or so heading into June. I'm going to be doing a couple of sessions in Oregon on the 26th and 27th, one for assisting the survivors of the decedent's estate, a second one on tax research, sources, methods, and documentation. Robert Gilwey's got a 3-set of courses coming up in Connecticut, navigating divorce tax litigation issues on June 6th, on the 7th, partnership and LLC taxation advanced issues, and introduction to international taxation on June 8th. And Butch Rogers will be lecturing in Iowa on church and minister taxation on June 8th. Be sure to check your state CPE, your state societies for all of their CPE offerings, including those that we offer and those of the others. And take a look. Remember, it is time now to start thinking about this, so it's time to get going. With that, let's go ahead and run to our first case this day. We're going to take a look at actually a set of regulations. These are temporary regulations, and as I get them going in the right order, that were issued. These temporary regulations, regulation under Section 301-7701-2T, E8I, and similar proposed regulations, they're going to deal with an issue, and we'll have a brief summary here, then Don and I will start discussing how this works. But we're going to have, the IRS is dealing with partnerships that have been treating partners as employees of single-member LLCs. And it turns out the IRS has now issued regulations making clear that they don't believe it ever worked and that it certainly doesn't work now. And the reality is that we're going to have a little bit of an issue here because the IRS issued this initially with a delayed effective date. Now that effective date is no longer delayed. And in fact, what we turned out is it will actually start now. There was a little confusion when they published in the Federal Register about how it worked. But effectively, starting here on May 4th or in August, so plan years are tied in May 4th, and August 1st, we have to convert. If we've been treating these people as employees, we have to start treating them as non-employees. And Don, what exactly does this mean, and why is it an issue whether a partner is an employee or not?
Well, I think that the biggest issue here is that as a partner, of course, you're limited to the amount of benefits that you can get. You don't have the same rights as an employee to participate in the health plans and certain other fringe benefit type plans. And that's always been a problem. I think we also had some issues in talking with people around the country, especially it seems like in the East Coast, there was a number of our usual suspects, which are the law firms, that when they brought on a new partner, they didn't like the idea of becoming self-employed. They didn't like the idea of doing estimated taxes. So they wanted to continue to be employees and have withholdings. And so they continue to issue W-2s, et cetera. And it seems as a part of these proposed regulations that while they're not dealing specifically with a lot of those issues, the IRS is inching ever so slowly towards this idea that partners should not be employees, but rather being treated as self-employed individuals.
In fact, it goes back to an old revenue ruling in the 60s, right, where the IRS simply by fiat announced that a partner could not be an employee of a partnership. And they've back referenced this again. And Don, your experience is kind of like mine. I've found most people I talk to who have set up organizations or who have partners who are, quote, W-2 employees, it's not been so much they're trying to get some employee benefit. It's more that, yeah, they just don't want to pay estimated taxes. But I don't think, and in one sense, that wasn't what the IRS is aiming for, but it's still just as effectively wrong and creates an issue. And certainly as of August, the IRS has made it very clear that this doesn't, that it's not okay to have your W-2 employees. And I think that's going to cause some concern among people who aren't really have plan problems, but have more simple employee problems.
Yeah, and the real issue here with these regulations is the fact that, well, somebody figured out that the IRS, in applying the check the box rules, had to figure out what it means to be a disregarded entity. And one of the exceptions, and while the regulations under 7701 talk about disregarded entities as applying to all tax matters, they refine that later on and say, well, because employment taxes are different, we're going to treat we're going to respect the entities, if you will, for employment tax purposes. So what happened then is that the clever folks out there said, well, if you're going to treat these LLCs as the employer, essentially like a corporation, instead of like a non-existent entity, then why can't we have those individuals that are partners be employees? And that's how they ran with the ball here. And the IRS saw that and said, no, that's not really what we intended, so that doesn't work.
Right, because what they had was an example in the regulations that said if you were a sole proprietor and you formed a single member LLC, that it's still, for self-employment tax purposes, you were still the proprietor, but they didn't specifically mention partnerships. And that was where some people said, well, because partnerships weren't mentioned, then partnerships could go out, form an LLC they own 100%, and then be able to hire people there. And that's specifically what this is going to do, is add an example to the regs that says, yeah, for partnerships, it's the same as sole proprietors. It still doesn't count.
Yeah, and I think that's one thing. I mean, not only in this context, but broadly, as we're looking at the way the IRS is doing regulations and revenue rulings, et cetera, by publishing a lot of examples, people are saying, well, if it isn't in this specific example in the way that I want it, that must mean I can do whatever I want to or can take it to the next step. And that's a problem, frankly, with the way the IRS does things. But they are clarifying here, especially in this context, that no, that's not what it means, and that we can come back later and clarify it if we want to. But one thing that we have to watch out for here as practitioners is that I don't think we have substantial authority now to file a position where we have a partner as an employee of a partnership or the single member LLC. So we have to be careful, because it's very likely that, especially in ongoing and perhaps even for prior tax returns, that we may be subject to penalties along with our clients on the positions that we take here.
Right. And that's part of our problem. Yeah, going against a regulation is a little bit more significant than going against where you claim there's no true guidance.
Correct.
Okay. Well, the next case up we've got here is a case of Boyle versus Commissioner. We're going to take a look at this. This is Tax Court Memorandum Decision 2016-87. It's an innocent spouse case. And the interesting part here was the taxpayer's spouse had prepared the returns every year, presented to this person for signature, but it turns out she didn't file the return in the year in question. He wasn't aware of that. He did not discover this till after she died. So filed the Form 1040 before the IRS was contacted. Now, the interesting part is the tax court granted this person penalty and interest relief, even though all of the income that generated the unpaid liability, because she never filed the return, she never paid the tax, was all his from his Schedule C. None of it was hers. But he still, even though it was all his income, the tax court said that doesn't mean he can't get relief from the interest and penalties in this fact pattern. Don, do you understand kind of how the IRS's position was? Well, it couldn't be innocent spouse because it was his income?
Well, yeah, I think this goes back to Revenue Procedure 2013-34. 2013-34 came out after the IRS finally got religion on what it means to do equitable relief. When the statute was originally, Statute 6015 was originally put in place, they had a statutory relief for an innocent spouse. And then they also slipped in subsection F, which talked about this equitable relief. IRS didn't get what it meant to have equitable relief, really, and they had regulations in place that basically made the equitable relief have to go toe-to-toe with the statutory relief. And what we have to stand back here, and I think that the attorney in this case did a good job, even though there wasn't a lot of dollars involved. I think they were trying to make a point here that equity means that I don't get relief anywhere else, and it would be unfair to apply this law in this context. Therefore, even if I don't fit the facts and circumstances, one thing at a time, that I still should get relief. And the court, I think, was proper in the way that it applied this, even though the IRS still struggles with the idea of equity.
Right, because even under the revenue procedure with equitable relief, there's still conditions that you have to meet before the IRS will even believe it's possible you could earn equitable relief. The tax court said, well, those are useful in general, but we're not bound by those.
Right, and that's really key to this argument, and that's key for us to understanding what's going on with our clients. Certainly, in a lot of cases, we'll have situations where the innocent spouse is innocent from the fact that there is an active measures being taken by the other spouse to hide information, to defraud that spouse, actively defraud in the classical sense, in a criminal sort of sense. But in this particular case, in the Boyle case, I think that they're, taken in the best light possible for the clients. I had the sense that we had, I have this picture in my mind of a little old guy and a little old lady that have been married forever, and he's got this printer cartridge company that he's doing. He sells new cartridges in the daytime and refurbished cartridges in the evenings, and he's just making $20,000, $30,000, $50,000 a year at the most. She, on the other hand, apparently is a little more retired, although she took care of the books for the family. She also apparently did a fair amount of gambling, because she was adding about $15,000 to $20,000 a year from gambling winnings. And so I'm not, and eventually, and as you said, she died in 2006. So there may be some medical distractions. She passed away from cancer. So there may have been some other distractions. So we don't necessarily have, if you take the facts in the best light that possible, we don't necessarily have somebody that was trying to fool the spouse that was trying to get relief. We may just have a situation where she wasn't operating at full capacity, if you will, and that as a result of that, he didn't try to deny he owed the income taxes, didn't try to deny that he owed the self-employment taxes. He just said, well, up until the time that I found this out, I should not be subject to penalties and interest.
Right. And the court made a key issue that, for many years, it had worked perfectly for him to just rely on her to file the taxes. It worked. He saw the return. He reviewed the return. The return was correct. The problem was she just didn't file the return and didn't pay the tax. And he, in the court's view, reasonably didn't know that hadn't happened.
Right. And that's where the court did an interesting two-step around the definition of fraud in order to try to fit it within the parameters of the Rev Proc. Not a criminal type of a fraud necessarily, but a fraud where he didn't see, because the innocent spouse had always done it one way. He didn't see when she didn't do what she'd always done, and things broke down in the system. So, and also what was really important here, I think, is that the classic definition of equity says that you come to the court with clean hands, which means that you've done everything you could to try to make this thing work correctly. And in this case, the applicant said that, as soon as I found it out, I filed the returns before the IRS came back and said, "Where's your return?" He did everything proactively, and that, I think, went a long way with the court to find out that he did indeed deserve equity.
Right, because that was key, and it was important. The court made a big deal of that. And yeah, it just means that you have to look, when you're dealing with equity, you've got to look at the facts in the situation in front of you and understand that there's a little bit of leeway. It's still going to be one of those interesting little problems. It's never going to be easy to win when it's your spouse's income, but at least this case shows it's not impossible to win.
Right. We have to keep our eyes open and be willing to take that next step.
Okay. Now, next up, we have a little problem. Sometimes you get involved in complicated transactions, and that appears to be what happened here. We had a case of, this is Private Letter Ruling 2016-18003. We have an S corporation that had two trust shareholders. They had both executed QSST elections. All is well, all's going fine. Now, another S corporation is looking to take over this company. And the S corporation takes over the company and effectively ends up with a merger. So the old S corporations merged into the new S corporation. The shares of the old S corporation get stock in the acquiring company. The catch at this point was, though, these trusts did not make new QSST elections. They were holding now the stock of the parent company or the acquirer. They didn't make any QSST elections. Somebody discovered and noticed this, said, you know what, I don't think we're an S corporation anymore. IRS agreed, but the IRS did, after a private letter ruling request, grant relief in this area. So the issue becomes, Don, exactly, is this one of those cases, at least I took it as being very likely, that we just had a complicated situation going on where a whole bunch of things were happening, and this was just one of those little issues that kind of went under the table and nobody noticed it?
Yeah, I think that's how I read it too. We're comforted in the fact, and I remember back in the day when you had an S corporation, that if you admitted a new shareholder, they had to make the election to become to keep the S corporation going. We don't have to do that anymore. In fact, when I counsel my clients with a new S corporation, and they don't know who's going to be part of the S corporation, I say, well, I don't care as long as I have one shareholder and they own 100% of the shares at that time at the very beginning. We'll make the S election, and then you can bring in whoever you want to along the way. Right.
As long as you don't bring in a disqualified shareholder, we don't have a problem.
Exactly.
But this case was with the merger, we effectively brought in a disqualified shareholder.
Right, because they became very comfortable with having the QSST there and thought, wow, it's just, we're not changing anything. We still have the QSSTs. What could possibly go wrong?
And most likely, the ruling doesn't say, but I'm going to assume this merger was probably a tax-free merger under 368. So, you'd think it's a tax-free merger. It means that, tax-wise, well, quote, nothing's happening. That's oversimplification. But presumably somebody just assumed nothing's happening. And it's a complicated transaction that probably, how often do you have a merger involving an S corporation that has trust shareholders? I don't care what your specialty is. How many times do you hit that fact pattern?
Yeah, that's exactly right. So I think this is one of those PLRs that, while it doesn't directly, it doesn't apply directly for presidential purposes to other cases, it's one of those that you want to hold on to keep as a reminder when you're doing your checklist on complex S corporation situations, which, anytime you have a QSST, I think you've got complexities involved, that you need to make sure that your checklist includes this provision here. And in fact, why not in any kind of merger situation or acquisition of an S corporation, why don't you have that on your checklist? Is there a QSST in place? Do we need to re-elect?
Right, because one of the problem is the S corp rules don't play nice with a lot of the tax law. We get complications when somebody dies and the shares go into the trust that causes us problems, or, the shares go in the estate, then out of the estate where they go. All of these are interesting complexities, and quite often they may involve us dealing with experts who may be very expert in an area, let's say like estate tax rules and estate tax planning, but who may not often deal with S corporations.
Yeah, the two things that I think are certain in these cases is, first, if you rely on the attorney to give you the advice in this area, you're probably not putting your reliance in the right place, because they generally don't hold themselves out to be income tax people. They will get involved in the estate tax, etc. They're comfortable with that. The second thing that I think we can learn from this PLR, which is not necessarily the best news, is that you can get relief from these things, but it comes at a price. And it's the price of filing for the PLR, which is not cheap. The fees are they're almost $10,000, aren't they, for these PLR requests now?
Right.
For just the filing fee.
Yeah, I think basically you got the fees, and the IRS has been pretty clear in news we've had this week that those filing fees are likely going up in the future due to budgetary issues.
They are a source of revenue production for the IRS. They're much like the penalties are now. So fees for filing for the request, plus the time to actually put everything together. When back in the day, we used to say that it's a $20,000 to $30,000 proposition to do a private letter request, and I still think that's true. And probably even in many cases, it's going to be more than that. The one thing also I know about many of these cases is it's usually not the client that has to pay the bill. It's going to be one or the other CPAs, or perhaps the attorneys, although attorneys never get never get caught paying the fees in those cases. So it's usually going to be the CPA. So you have to be careful. Again, get it on your checklist. Understand that while you may be able to get the client out of the woods, it could cost you a lot in order to be able to do it.
Right. And now the other neat little thing we had this week, we have IRS is finally going to make use of something they did last year, allowing them to more simply update the list of automatic changes. And so we have a new list. If you have an automatic change, Revenue Procedure 2016-19, the list of automatic accounting method changes has now been consolidated into a new Revenue Procedure 2016-19. That was it, basically updated Revenue Procedure 2015-13, incorporated 2015-33, and Revenue Procedure 2016-1, revisions in those. It's actually the IRS last year telegraphed they were going here by breaking what used to be an appendix of the Revenue Procedure on how to do method changes into its own RevProc. And it is now effectively, whenever you make an accounting method change, this Revenue Procedure now is the one you go to for the list of what your number is, what the conditions are, and what the situations are. And I guess the issue here is, of course, first thing is, Don, what exactly is an accounting method? Because we have to know what one is to know if we're changing one, right?
Yeah, most of the things that we're dealing with as far as how we report the income and expenses deal with accounting method changes. Most recently, we had to go through that whole process with the new repair regs, and we talked a lot about what accounting methods may need to be changed as a part of those.
Right.
The IRS has tried to simplify our lives by giving us these automatic changes, but at the same time, we have to understand that we need to be able to identify exactly which type of method change we're doing for our client in order to know if we do get the automatic change or not.
Yeah, because the fundamental definition of a change is, or an accounting method is something that affects not the amount, but the timing of inclusion of income or deduction.
And I think that if you really spend some time to think about all the things that your client does, that's a huge part of figuring out what we put on the tax return and when we put it on the tax return. And anytime we do it for a consistent period of time, it becomes a method, whether or not we intended it to be.
And that's true even if the method is one that's not allowed under the tax law.
Correct. Now, I think the IRS tried to make it simpler for us by saying, well, we're going to have a standard form for reporting these, and made with all the automatic changes, they did allow us to they did incorporate those automatic changes as a part of their form. One of the things that they said was that we're not going to change the form every year just to accommodate them, but we will give you instructions that get revised regularly, and now these RevProcs that are there.
Right.
But of course, one thing that you have to remember is now, if you didn't catch on, there was a change in the form that was effective in December 2015 that now has to be used. There was a transition period, but now it has to be used.
Yeah, the transition period ended on April the 20th. So from this day forward, they will send it back to you if you send the old form in. And, and the key is to remember is you have to have the IRS's permission to change an accounting method. That's the big negative. And if the method, and in theory, that means going through the whole rigmarole, very much like a private letter ruling structure of trying to get permission ahead of time. But a number of these things that people are going to have to do, the IRS has put out automatic changes. So where you run into a problem where we want to change a method or we have a method that's not allowed, the first thing you do is you run to the automatic method change list to see if what you want to do can simply be accomplished via this. And I think it's like 320-page ruling.
Yeah,
list of them. Yeah, there's a lot of them. To see
you want to have a good search mechanism in order to figure out if you got the right place.
Right, because there's a whole bunch there. Okay. Well,
and I think I did a quick check in my UltraTax program this morning to see if they've got the new form in place, and they do. So I'm assuming most of our computer income tax reporting mechanisms do have the new 3115s within them, but you should always check that revision date whenever we come out of a transition period to make sure that whatever you're using is the newest and best form.
Right, and the revision date would be the December 2015 version of this form.
Yeah, the instructions haven't been updated yet, but those should be coming out, I would think, anytime now, the revised instructions for the form.
Right. Well, Don, it's been interesting doing this week. Let's go ahead, and what I'm going to start doing now is we're going to go ahead and remind you, since we're about at the end of our time frame that we'd like to run, This has been the current federal tax developments for this week, May the 9th. We do have all of the materials uploaded at the website, currentfederaltaxdevelopments.com. You can go there. You can look at articles on all the things we discussed today. You can also download a PDF of the articles that relate to today's session. You can sign up as well for an email of articles as they are posted on the site. Also, be sure to check your state society's catalog for live continuing education courses that we're going to be presenting. And Don, I want to thank you for being here this week. And
thank you for having me, Ed. It was a lot of fun.
Okay. And we'll take care of that. And we'll see you all next week as we go ahead and continue with all of this neat stuff going on in the area of federal taxes.